And here we are. Got it running. So welcome, Eric. Good to see you.
Thank you.
And welcome to the Deal Doctor live stream. It's Monday. And today we're going to talk a little bit about when we go out to get a listing, how do we get the authority? How do we know that the person who has contacted us and wants to list a property has the authority to do that? We actually had a number of questions last week about it, which is why we're having the conversation today. And let's first of all talk about powers of attorney. Very often we hear people say, well, I have the power of attorney. What does that mean, Eric?
Means nothing.
Perfect. Good answer. Good. Eric, thank you all for joining and have a nice day. No,
Yes.
but exactly. It means absolutely nothing. Sometimes people say, well, my cousin or uncle or brother or parents told me that I have the power of attorney to handle their business affairs. Does that have any legal standing out there? No. The answer is no. But let's say that they actually did give a power of attorney to someone for, let's say, paying their water bill and their gas bill, doing their banking for them. Does that power of attorney extend to selling real estate for them?
No. So again, we have to go back to power of attorneys. They are tricky. When we say power of attorney, I guess what we really need to be saying is that's a generic group of multiple types of power of attorneys. And a power of attorney is not truly granting someone power to do everything for that individual. There's durable powers of attorney specific for just selling real estate, maybe for a particular property. There might be power of attorney in case someone is incapacitated and they can't make medical judgments. Although then there's going to be something else there. There's going to be other documents specific for hospital care and medical care. But when we're focusing on the power of attorney for real estate, it really needs to spell out what that person is being empowered to do and sell. And so just because somebody has a power of attorney, most likely it's not going to be to sell the real estate in question, in my
Most
opinion.
likely, that's going to be the most extensive form of power of attorney that you can get out there to sell real estate. Now, so if somebody says, well, I have the power of attorney to sign on behalf of these people and sell their real estate or whatever, what should we be getting from that person who's making this claim? And what should we do with it next? Should we maybe have the title company review it, for example?
Well, if it were me, I would want a copy of the power of attorney. I would want to know who the attorney is, because I'm going to be picking up a phone and talking to that attorney and asking them, hey, look, I'm Eric Graham from 5 Star Real Estate. I've been approached or asked to list this home, and I see that they are under a power of attorney. Does this power of attorney cover the ability for this person to represent the owner of the home and to sell the property? That's going to be my first call. Because my position would be, I don't even know why I'd be reaching out to the title company just yet, because my due diligence is to determine who I need to work with. And if that attorney says, no, sorry, Eric, this power of attorney is for other forms of overseeing the property and the care of the client, this will not be sufficient. Okay, well, then now I can go back and say, hey, look, I had a conversation with the attorney who has the authority. Please let me know who I can talk to move this along, to get to your final goal of selling the home.
So bottom line, first step, if you hear the words power of attorney, you should say, I want a copy of that.
You need a copy of it.
Okay, let's go on to the attorney. The attorney in fact. What is an attorney in fact? And does an attorney in fact have the authority to act on behalf of a buyer or seller of real estate?
Well, I'd have to look into the attorney in fact.
Right, well, I'm sorry about that. So an attorney in fact does.
I would say yes, but I would still need to be verified.
Exactly. Even in a power of attorney in fact situation where an attorney can act in legal standing in creating enforceable contracts on behalf of their client, signing as, Jack Jones, attorney in fact for Eric Graham, for example. That's how it might go. Even in those kinds of situations, we would want some kind of verification that in fact, Jack Jones is Eric Graham's attorney, right?
Correct.
And
Yeah.
has the authority to act in his behalf to transact real estate business. So again, we have to verify everything, single step we have.
And Don, if I were to call an attorney and they said verbally, yes, this is allowed, I would be asking them if they could just kindly send an email, just letting me know, maybe introducing themselves, so that you have a record now in writing that what they're claiming.
Exactly. Always get it in writing. Always establish that paper trail and keep that paper trail to protect yourself. Let's talk about when you said power of attorney in extenuating circumstance. Someone's incapacitated, or maybe they're going in for surgery or something, and they're going to be out of commission for a couple of days or more. What kinds of legal entities are there to help people transact business on their behalf? There's guardianships and conservatorships, right?
Correct. Or if someone is incapacitated, court ordered, a personal representative. If someone doesn't have family
Okay.
to be a guardianship or
So in the case of someone who is working with diminished capacity, we often talk about clients with dementia and Alzheimer's. And so they're working with diminished capacity. How do we protect them in transacting business for them? Do we need to have an attorney involved, a court order, for example?
it's a very tricky fine line when you're dealing with someone who you think as an agent might have dementia or early Alzheimer's, or maybe they're just forgetful. Again, we are not licensed physicians to be able to diagnose someone. If family members are there saying, hey, Don, I think my mom or father might have diminished thoughts, and sometimes they're not able to remember things, that might be a red flag. That all of a sudden we might need to put the brakes on things and say, okay, I hear what you're saying. We might need to have a conference call here with all parties involved. And you still might need to go to the next level of, hey, I really think as a family, you need to hire an attorney and do this properly. Now, most time the public's very cheap. They don't want to pay for legal advice,
Mhm.
but we need to encourage them. We need to let them know, hey, there might be a situation at times where legal advice needs to be consulted upon. Anytime we have someone that we might believe could be having diminished capacity to be able to execute contracts.
So yeah, there's a different, and this is a really good time to encourage everyone to watch the Con Ed portion of elder law that Katie Aguilar helped us with this year in Con Ed. She does a fabulous job of explaining all of these nuances of diminished capacity as it regards clients of our that we may encounter, and we're not prohibited from working with people who may have some slight diminished capacity, but haven't reached the point of complete, full-blown dementia, for example. So encourage you all to watch the Con Ed portion of elder care. And I don't want to spend a lot more time, but understand the difference between guardianships and conservatorships. A guardianship simply means that they can pay the bills, keep the lights on, pay DTE energy out of the checking account, buy groceries and that sort of stuff. When it shifts to a conservatorship, then the person is taking over all of their financial affairs. But they still have to work on behalf and in the best interest for that client, whatever that might be. But let's move on from that to issues of trusts and LLCs.
Oh, yeah.
And let's go down that road. So we have this property that we want to list, and we discover that it's owned by a trust. Let's go there first.
Okay.
What do we do?
Well, with any trust, and if you hear the term trust, or if you're doing preliminary title work and you see that it's in a trust, we always want to make sure that we get what's known as a certificate of trust and authority. So it's not a true certificate. It's a document. Could be a 1 or 2 page document. It's just called certificate of trust, existence and authority, but it spells out who has the ability to make decisions on behalf of the trust. Now, it may name a single individual as a primary person. It may actually name a secondary person in case the first person is unable or unwilling or not even wanting to oversee the trust. So we need to read the fine language in that trust to determine who the main decision maker is, and then verify with that individual in an email saying, hey, now I'm seeing that this certificate of trust and existence is stating that you are the primary executor of this trust. Are you going to be the person being able to make the decisions and wanting to accept this role? It's very simple. You're just trying to verify what the document already says, because if there's 2 people involved, you might need to get the signature of both parties for that trust through the entire transaction. So it's just a matter of have to read that certificate and find out who's the main person, or 2 people that might be, or 3. You just don't know.
You're exactly right. Until you read that certificate of trust, existence, and authority, you're not going to know what the rules are. It's that simple. And very often, when you get that, it may be difficult to read. It may be hard to comprehend. But you'll find a lot of times that there may be 4 or 5 or 6 beneficiaries to the trust. For example, the children of a deceased couple who had the property held in trust, and of those 4, 5, or 6 individuals who are beneficiaries to the trust, 2 of them, 1 of them, 3 of them could be signatories to the trust, that there are at least 2 or 3 signatures required of those individuals in order to transact business on behalf of the trust. I think that one of the key points that we have to keep in mind when we are dealing with trusts is that no matter who is designated as the signatory to the trust, they always have to keep in mind the best interests of the trust. They cannot be acting in their own behalf, even though they are the singular signatory to the trust. If there are other people in the trust, they have to continue to work on in the best interest of the trust. But again, we got to get that document in order
Yeah,
to
and
look
I've always liked
understand.
to tell agents, think of a trust as a separate individual, because that's what it is.
Yeah, exactly.
The trust is a person. Think of it that way. And they just can't talk or speak, but someone else is speaking on their behalf. But the trust is a separate entity.
Yeah, that's a great way to put it. And that brings us to LLCs. They too are a separate legal entity. They're not an individual. They are not a partnership. They are a limited liability corporation. Therefore, I want to buy or I want to sell a property, and I own it in an LLC. It is owned by an LLC. What do I do now?
Yeah, well, let's step back and say, well, maybe it's not an LLC, but maybe it's also a subchapter S corporation, or an S corp, or a C corp. Now the only difference between S corps and C corps, they operate pretty similar, but then you have the LLC, and you're going to need to verify who the owners are of that LLC. We normally have what's known as articles of organization for an LLC, compared to S corps and C corps, which they have articles of incorporation. Now they're very similar. It's just that One's called organization, one's called incorporation. But when you do go to file for these, they do operate differently and they have different tax advantages. But with an LLC or any corporation, you need to understand what their articles are and maybe even a copy of their bylaws to understand who can make the decisions on behalf of that company or entity. Now, sometimes the easiest thing to do is to ask the company, the president of the company or CEO or whoever, or their board, to provide you with a authorization of resolution. Or just say, hey, can you guys have a vote and just simply put something down on a piece of paper that says, an authorization of resolution, or the board hereby has determined that Mr. Smith will have the ability to make decisions on behalf of this purchase or the sale of this property. Now, keep in mind, boards do this all the time. They use these authorizations of resolutions for significant business actions, like for getting a loan. And if you represent an LLC, the banks most likely will require them to do this. But if you understand that, hey, their company just needs to come together and just vote on it, that this person is going to be the voice of the company and has the authority to purchase this property or XYZ, that's what you need. And the banks are going to want to see that because it makes it easier for everyone. Now, you're not going to see that for day-to-day operations in any type of LLC or S Corp or C Corp. It's just during these significant transactions within a company. And it just makes people's lives easier, so that as a buyer's agent, you're dealing with one signature because you have that resolution, that authorization to
So,
move forward.
let me take the most simple example and say, the seller says they are the sole owner of an LLC. Even with that circumstance, what would a smart agent require in order to move forward with listing that property?
I mean, typically, I'd always want to see their articles of organization and their bylaws, because that's what will spell out who has the authority to act on behalf of the company. I
Exactly.
mean, if you really want to dive down deep, that's what you need. Or you can go online. The Michigan Lara, the websites, you can find any articles of organization or incorporation, bylaws, certain resolutions each year, whether a company is in good standing. All that information is online. You just got to dig into Lara's website and find the company name, and you'll be able to find that information and pull it out. But any good company will have that in their dockets, their books. They'll be able to send that right over to you. That should not be, that's a very simple request.
So let's dive a little bit deeper. One more. Let's take it a little bit a step further. What about estates? There's a will filled out, signed by the deceased, and it names Charlie as the executor to the estate. What then?
Yeah, this makes it a little more challenging because, at least in my opinion, I don't know whether that will has been contested by anyone else in family. And I would have to try to determine who was the attorney who drafted that. Maybe you can have a conversation. The problem is, what if someone goes to LegalZoom for $199 and creates their own will and says, okay, I mean, if this individual was named in the will and had, death certificates, had proper protocol that they were following, it could be a lot easier. But still, sometimes with wills, they still need to go through probate for verification and approval.
Absolutely. You're exactly correct. Wills do have to go through probate. Just because someone was named as an executor to the will to the estate does not mean, in the will, does not mean that they can go out and sell a property. It's still going to have to go through probate for the probate court's approval. It's that simple. So if you hear this, and while I was named executor to the will, here's the document, here's the will that mom and dad gave me to sell this property in the event of their death. Guess what? You're still going to have to take that to the probate court. You're still going to be looking at probably anywhere from 30, 60, 90 days before that property is going to be able to get sold. So it's best to learn that up front before you put it out there on the MLS and run into problems. What about when people add their children to they quit claim ownership to the property to join them in ownership as, for example, mom, dad, and daughter, for example. What happens then when the property gets sold?
Yeah, so it can be a mess sometimes.
Good start, really good start.
You have a lot of layers now with a quick claim. Let's say mom and dad quick claim to a child, thinking that, hey, this is easy. I mean, I'm just going to quick claim it. Well, you've just now attached liability to that child for any type of loans, if there are on there, that they're responsible, and tax ramifications, which is massive, which no one ever talks about, because that child who got quick claimed on it, if mom and dad bought the home for 50,000 and now is selling it for 400,000, well, that child is now taxed because their basis
They got
is
a lot of cap gains to
they have a
explain.
lot of capital gains on that.
Yeah,
Instead, an attorney could have drafted a document preventing even uncapping and certain taxes. So a real estate attorney would have been wise to have that family get involved with before they do any type of quit claim to a child,
oh yeah, absolutely. And
because of the
another thing that we
tax
ran into that I
and
learned,
sale ramifications, trying to sell something now.
and when I was with recording Con Ed with Katie Aguilar, I think one of the things that came up was a topic called undue influence. If one child has undue influence with the parent who owns the property and who adds them to the property's ownership through quit claim deed, the other siblings could potentially challenge that claim with saying that, she took care of mom every day, she was there every day, so she exercised undue influence in having that property now put in her name as well. So there are a lot of issues that happen, that when we go out and we're talking to clients, especially when we're listing their property for sale, we have to ask a lot of questions, get the information, and then call broker support and get guidance along that, as to what to do. And sometimes we're going to tell agents they really need to get an attorney involved in this situation, because it may involve an LLC, it may involve a parent who is suffering with reduced capacity due to dementia, all of those sorts of things. So get as much information as you can. Give us a call. We'll help guide you through the process. Anything else, Eric?
No, I know there's a lot there.
Yeah.
And I think the biggest thing is just asking questions on who the key players are, who the owners are, and then verifying. Just taking an extra call or two, whether an attorney is involved, and it might take a couple days, but just understand that just keep going. I mean, you got to do this up front, because if you don't, you're going to waste a lot of time and effort getting to the very end thinking that you're about to close, and then realize that the last 3 weeks, 4 weeks were for nothing now, because now we got to go back to the courts and through probate, or we have to do something, or something was contested. It's just not worth your time.
Yeah.
So do your homework up front, or
Exactly.
call us on the broker support line.
You bet. Call us. We're here to help you. Eric, thanks again for joining.
Don, thank
All
you.
of you out there for joining. And
as usual.
What's that?
I said thank you as usual.
You're welcome. And we'll see you next week.